Connie, I'm going to pass it over to you in terms of painting with a broad brush what Tennessee custody laws are, and then how they actually play out in the courtroom.
Okay, yeah, thank you for that. And again, I'm going to, I want people to sort of understand that my perspective is based upon 27 years. So, when I came into family law, and law was a second career for me, so I'm getting pretty old. But when I came into family law, we were on what was called the standard visitation program, right? Basically, as soon as you walked in a courtroom door, you had to tell, or you had a burden, you had a hill to climb as to why a father should have anything more than every other weekend and 2 weeks in the summer. I mean, it was really kind of shocking, actually, but that just seemed to be where we were. Now, every law that is made has to be implemented by a judge. And I work in circuit courtrooms, chancery courtrooms, general sessions courtrooms, juvenile courtrooms, and every judge is different. And I say they come in 32 different varieties, just like ice cream. And so you have to understand your judge. A lot of the judges that have been on the bench for a very long time have a really hard time adjusting mentally to changes in the law when it comes to custody. I tell all my clients, I say the courtroom is the judge is the last person in the world who should be making decisions about your child, because your child is nothing more than a name, a date of birth, and a social security number to your judge. Until you can personify that child to the court. And I mean, I work on that with clients. I'm like, what does your child like to do? What do they like to wear? I always bring photos. So you have to personify the child to the judge so that it does not look like, when you get in the courtroom, that the custody battle is a personality battle between a man and a woman. So critical. So I've represented men, I've represented women, I've seen women who've been abused by the system, I've seen men who've been abused by the system, and being prepared, every single parent being prepared is absolutely critical.
All right, awesome. I got 2 points I want to ask you to dive a little bit deeper on. So one's a very common question that I get. I think a lot of dads get. So you mentioned the judges, and you get a judge who's been on the bench for 20 years, 30 years. Like they basically planted roots, and they struggle to adjust. What can an individual do to effectively navigate that? Because in a lot of states, once they make an order, you're kind of stuck unless there's some misconduct.
Well, yes, absolutely. And custody decisions are, and as attorneys, we can talk this language, and I'm sure a lot of other people don't understand it, but custody decisions are reviewed on an abuse of discretion standard. So basically, you have to show that the judge was so far out in left field, so to speak, that absolutely nothing, he should have never done what he did. And I have appealed custody decisions, and I've wrote appellate appeals, and there's some of them I've won, and some of them I've not been able to budge anybody on. But, the judges have really, really broad discretion. So you need to know the judge, and hopefully you have an attorney who has some experience with the judge, or the attorney themselves have some type of reputation that precedes them into the courtroom. So I kind of course, started at the place where I just had to experiment with judges and get to know them. And, I give judges, I treat judges like people instead of like some kind of statue that's just sitting up there to intake information, and try to observe them and watch their behavior and their conduct and their comments. And, one of the things I tell clients who are testifying, I say, when you're on the stand and you're testifying, you keep your eyes on me and watch everything I say to you, and listen very carefully, because I'm promising you that I am watching you, the judge, the court reporter, the opposing party, and the opposing counsel. And I have my eyes on all of those people. And if I see a judge is maybe getting, judges, they're not very good poker players. So sometimes they get a funky look on their face, or they're not even listening at all. They're like making notes, or they've leaned over to talk to the clerk. I mean, you have to be very keen on what's going on. And I say, look, if I ask you the same question twice, don't think I'm trying to necessarily get a different answer, because I want your answers to be consistent. But the reason I'm asking you that is because the judge either wasn't paying attention or was looking away. And if you give me an answer and I prod you to go further with that, there's a reason that I'm doing that. So your attorney has to understand the judge. And, I now, having had done this for 27 years, I pretty much have a reputation that precedes me in at least a third of the counties in Tennessee. So, the judges know I'm going to be prepared. I'm going to know the law. I'm going to have all my exhibits. I'm going to have all my evidence. My clients is going to be as prepared as I can make them. So knowing your judge and how your judge is going to play into this is very important. And I will say that also includes, because there are some counties where what we call, and I don't know if this has happened to you yet, Mark, but we call it you get home cooked. When you walk into a county that's maybe 2 counties away and there's a local attorney there and he plays golf with the judge. And, so you have to be very, very tuned in to the relationships of the other attorneys with the judges as well. And that's just the reality of it.
Yeah, no, I have not personally experienced that. I happen to be in one of the most densely populated areas of the country, being out here in Southern California. So there's multiple courthouses. There are some courthouses have 24 judges in them. But I have definitely seen where you get to the small rural counties, especially up north out here in California, and it's 1 judge, 2 judges, and they know all the other attorneys, and they like some, they don't like others, and you can be in a really tough spot.
Mm-hmm. And you have to be very brave and I kind of like rural counties. I mean, I work in metropolitan Nashville, which is about, I don't know, I guess it's a little over 1 million now. And then in my county, which is probably about 250,000 just south of Davidson County. And I like that metropolitan feel, but I also like a lot of the small counties. And so, I mean, I go into those courtrooms with a presumption that the judge is going to have a certain level of favoritism. And let's just start from, that's just my starting point. And then you have to work around that and, just be extremely prepared when you walk in.
Yeah, definitely. So we talked about the burden of appealing a custody decision and how challenging that can be. And that kind of parlays into you guys in the state of Tennessee did get a big win this year in terms of legislation. We always talk about, and you hear a lot of conversation around really 3 pillars of a very strong custody law that we're looking for: the presumption of 50-50, the standard to rebut that presumption, and the one that doesn't get as much attention but is maybe the second biggest deal behind that presumption of 50-50 is getting facts, findings, and conclusions. So I'm gonna share my screen here because we want to show you guys some things. So Connie, can you talk about the bill that got passed in the state of Tennessee and what it means for custody cases?
Yeah, so this is a pretty big change. I will also tell you, language in laws is very, very critical, because if a judge wants to pervert the law, he will pervert it through the language of the law. So there is a presumption. Before, we had a presumption of near equal time is what it was called, and that the court would have to make certain findings of fact. But now they are saying that there's a presumption of joint custody, and that if the parties agree, they don't have to have findings of fact. And this is a really, believe it or not, this little tiny thing is really a good thing, because for a while there, we had parents who would agree to 50-50 custody, and they would go in the courtroom and the judge would say no. I would be like, what? I mean, they would totally agree. So now they're saying that if there's an agreement and the people sign off on an agreement, there doesn't have to be any findings of fact and conclusions. But if there's not, and there's a hearing, and there's still, there's all kinds of language in here about saying that the court has wide discretion, which is, still a marker. But it says that there will be, if there's a hearing, that there will be a presumption of joint custody by a preponderance of evidence. And that unless the court finds by clear and convincing evidence to the contrary. So So we've got two things happening here. One is called a standard of proof, and one is called a burden of proof. And they're very different things. And to the layperson, they totally get lost in that language. But the standard of proof is really how much you have to put in the bucket. So a preponderance of evidence is just a little more than 50-50. It's just like, okay, we just got to tip the scale in favor of one person or the other. And clear and convincing is supposed to be like almost topping it out, as like in criminal, the criminal standard is beyond a reasonable doubt. So I know some people get confused and they think it's beyond any doubt, but no, it's beyond a reasonable doubt. So clear and convincing is supposed to be a very, very high standard. I will tell you that the courts, because I work a lot of juvenile cases which require a clear and convincing standard of evidence, I do not believe the courts are very good at distinguishing between clear and convincing and a preponderance of evidence. And there still is such a discretion there, it makes it very, very difficult. So I like the idea that we have the language in there, and with some very good representation and good attorneys who are prepared to walk into the courtroom and argue the standard of proof, which is a firm conviction, okay, not more probably than not, but a firm conviction as to the facts are to one side or the other. And, this is a challenge, and I'm just going to say to your listeners, and I really hope that your listening audience has two things that they are going to develop personally. One is to be really prepared to go forward, be good prepared litigants, be prepared to tell their story and feel comfortable doing that. And the other side of that is I want them to be prepared to be good activists, because we need more people constantly involved with our general assemblies, helping make sure that we have good laws. And maybe we do a show one time just on that issue. But as to preparing for court, that clear and convincing standard, you are going to have your story crystal clear, and you need evidence, and you need to, you get into she said this and he said that, and there's no balancing. The judges' minds just blow up, right? Because they cannot, they make credibility determinations based upon tiny little things. So being super prepared inside and outside to walk into the courtroom is going to be the critical thing of being prepared to be successful and still ending up with joint custody, even under this bill, which I think leans us. I think it leans you a little bit. I don't think it leans you really as far as the fathers' rights movement would like.
Yeah, I would say that the facts, findings, and conclusions, if NPO were to grade out the state of Tennessee again, maybe bumps you up to a C+, maybe a B-. But let's turn and let's first to our viewers. I have put the link to the Tennessee General Assembly bill in the comments. Go take a look at it after the show. This is a way you can educate yourself. This is a bill that gets one of those proverbial first downs when it comes to truly getting to equal and shared parenting. And the biggest thing, as Connie talked about, how can we create change, is being that activist. And you have to be able to have educated conversations. So if you can go and look at these bills that did get a first down and you understand why, you can have those educated conversations with your elected officials on the positives of these bills and to help get them passed.
Yeah. And let me talk a little bit about the facts, findings of fact and conclusions of law. That's what it is. So this really hit our Court of Appeals. Really started hammering the trial courts probably 6 or 7 years ago now, because a lot of orders, not just child custody orders, but whether it was wills and probates or summary judgments, the judges were just ruling almost, totally subjectively and not really putting down the basis of how they reached that decision. And so our Court of Appeals was just really laid the hammer down. And there is what is in Tennessee, it's Rule 52. And we pretty much follow the federal rules. So California probably has something very similar, is that if you get an order from the court and the court does not put findings of fact in there, you can file a motion for Rule 52 and ask the court to make findings of fact. So, but the Court of Appeals, but you're not required to do that. And so people would go to the Court of Appeals, and the Court of Appeals would say, I don't know what the trial court did. I don't know what they made their decision based on. And so they really, really started hammering it. And then there was this whole learning curve, because there is a distinct difference between a finding of fact and a conclusion of law. So a finding of fact is the sky is blue. A conclusion of law is it's a pretty day out today, right? So you still had judges who would say it's a pretty day out today, and you would go, basically like, what are you basing that on, right? Or it's not raining, or what is it? So very important to push your judge. And if you have a good attorney, your attorney is going to know before they walk in the courtroom what findings of fact they want the judge to make. And they're going to know at the conclusion. Some judges allow or ask the attorneys to write the findings of fact and conclusions of law and propose them to the court. I kind of call that the lazy judge's way to do it. And then they pick one or the other, and again, still, sometimes it's still by preference or attitude or subjectivity. But your attorney and you, as the client, as the father, as the parent, when you walk into that courtroom, you need to know at the end of the day, what do I want this court to find as a fact in my case?